Welcome, you're tuned in to a special edition of Ranting Politics Headline Updates, where today we're diving deep into the Supreme Court's biggest bombshell decisions of 2024. And trust me, the justices have been busy reshaping America's legal landscape in ways that'll make your head spin. Coming up, we've got a packed show covering everything from presidential immunity, yeah, that whole Trump situation, to the heated battle over Title IX and transgender rights. We'll break down how the court just changed the game for social media companies fighting state regulations, and why overturning something called the Chevron Doctrine has Washington bureaucrats shaking in their boots. Stick around as we unpack these landmark rulings in our signature no-nonsense style. Whether you're a legal eagle or just trying to make sense of the headlines, we've got you covered with the most important Supreme Court decisions that are guaranteed to impact your life for years to come. In what might be the most consequential Supreme Court ruling of 2024, the justices handed down a bombshell 6-3 decision that fundamentally reshapes how former presidents can be prosecuted. And let me tell you, this one's a game changer. On July 1st, the Supreme Court ruled that former presidents have substantial protection from prosecution, delivering a major victory to Donald Trump right in the thick of his presidential campaign. While the court didn't completely dismiss the case, they effectively ensured there wouldn't be any trial before the November election. Chief Justice Roberts, writing for the majority, laid down some serious constitutional real talk. He made it crystal clear that while presidents aren't above the law, Congress can't criminalize actions taken while carrying out legitimate executive branch responsibilities. The court emphasized that presidential immunity only covers official acts, meaning anything presidents do outside their official duties is still fair game for prosecutors. This ruling sent shockwaves through the legal and political world, especially since it came at such a critical time in the election cycle. The justices kicked the case back down to the lower courts, leaving some big questions unanswered about exactly how this immunity applies to efforts to overturn the 2020 election results. The decision essentially created a new legal shield for presidents, past and future, while trying to walk a delicate line between presidential protection and accountability. As we now know, this ruling had massive implications for the 2024 election, where Trump went on to secure his return to the presidency. Let's dive into another major Supreme Court blockbuster from 2024 that sent shockwaves through educational institutions across America. The Department of Education versus Louisiana case put the brakes on the Biden administration's ambitious attempt to redefine Title IX protections, and the implications are huge. The Supreme Court's unsigned opinion on August 16th kept preliminary injunctions firmly in place, blocking the administration's new rule that would have expanded the definition of sex discrimination to include sexual orientation and gender identity. This wasn't just a minor technical ruling. It was a full-court press against one of the administration's signature policy initiatives. What makes this particularly spicy is that all 9 justices, yes, even the liberal wing, agreed that the plaintiffs deserved preliminary relief, especially regarding that central provision redefining sex discrimination. The court basically told the Department of Education they hadn't done their homework in showing which parts of the rule could stand independently. This decision protected the decades-old interpretation of Title IX that's been particularly crucial for women's athletics. Louisiana Attorney General Liz Murrill wasn't kidding when she called Title IX the most successful law for ensuring equal opportunity for women in education since the 19th Amendment. The ruling effectively kept the status quo in 26 states where separate court injunctions were already blocking the rule. For those keeping score at home, this means the traditional sex-separate teams and spaces remain protected under the existing framework, putting a significant roadblock in the path of the administration's broader gender identity agenda in educational settings. As reported by Fox News, this ruling represents one of the most significant pushbacks against the Biden administration's attempted regulatory changes in the education sphere. In a landmark decision that rocked Silicon Valley and state capitals alike, the Supreme Court dropped a major ruling on July 1st, 2024, that kept social media giants like Facebook, TikTok, X, and YouTube safe from heavy-handed state regulation. This wasn't just any ordinary case. It was a full-blown showdown over free speech in the digital age. Justice Elena Kagan, writing for the majority, essentially said these platforms deserve the same kind of First Amendment protection as traditional newspapers when it comes to picking and choosing what content to host. The court's message was crystal clear. Just because we've moved from ink and paper to pixels and processors doesn't mean the fundamental principles of free speech have changed. The case stemmed from ambitious laws in Texas and Florida that aimed to crack down on what Republican leaders called liberal censorship of conservative voices. These laws weren't subtle. They were direct responses to social media platforms booting then-President Trump after the January 6th Capitol riot. But here's where it gets interesting. While the court protected the platform's rights, they also sent the cases back to lower courts for a deeper dive into the constitutional nitty-gritty. They're basically saying, hold up, we need to look at exactly how these laws might work in practice, not just in theory. Remember when Florida's Governor DeSantis called this a fight against Silicon Valley elites? Or when Texas Governor Abbott declared social media the new public square? Well, the Supreme Court just reminded everyone that in America, even our virtual town halls have constitutional protections against government overreach. Let me tell you about a bombshell Supreme Court decision that just rewrote the rule book for federal agencies. In a 6-3 ruling that sent shockwaves through Washington, the court overturned the 40-year-old Chevron doctrine. You know, that old rule that basically gave federal agencies the benefit of the doubt when interpreting fuzzy laws from Congress. Chief Justice Roberts didn't mince words in his majority opinion. From now on, federal judges need to use their own judgment to decide if agencies are coloring within the lines of their authority. No more automatic deference to bureaucratic interpretation. This is huge, folks. We're talking about a complete shakeup in how regulations get made and enforced in this country. The case that triggered this earthquake? It started with some Atlantic herring fishermen who weren't too happy about having to pay for monitors to watch their catch. But it turned into something much bigger, a fundamental challenge to how much power federal agencies should have. For 4 decades, the Chevron doctrine was like the holy grail of administrative law. Whenever Congress wrote a law that wasn't crystal clear, which, let's be honest, happens more often than not, agencies got to fill in the blanks. Now that safety net is gone, and agencies like the EPA, OSHA, and others might find it a lot harder to push through new regulations. The Biden administration warned this could bring a convulsive shock to our legal system. But conservatives, who've long argued that unelected bureaucrats had too much power, are celebrating this as a victory for constitutional governance. One thing's for sure, the way Washington works just got a major overhaul. Source: Fox News reporting by Chris Pandolfo, Bill Mears, Shannon Bream, and Brooke Singman. In a landmark ruling that's reshaping the legal landscape around January 6th cases, the Supreme Court just sided with a former police officer who challenged his conviction for federal obstruction. This isn't just any decision, folks. It's sending ripples through hundreds of similar cases tied to the Capitol riot. Let's break down what happened in Fisher v. U.S. The court voted 6-3 to narrow how prosecutors can use a federal obstruction statute that's been crucial in many January 6th prosecutions. We're talking about a law that previously could land someone up to 20 years behind bars for obstructing an official proceeding. The Justice Department had been wielding this statute like a broad sword, arguing that disrupting the certification of the 2020 election qualified as obstruction. But Chief Justice Roberts and the majority basically said, not so fast. They ruled the government was stretching this law way beyond its intended scope. Attorney General Merrick Garland didn't hide his disappointment, calling January 6th an unprecedented attack on the peaceful transfer of power. But he was quick to point out that most of the 2,400-plus defendants won't be affected by this ruling. Still, for those charged specifically under this obstruction statute, this decision could be a game changer. This ruling forces prosecutors to rethink their strategy for some of the most serious January 6th cases. While it doesn't let anyone off the hook completely, it does narrow the legal tools available to the Justice Department in prosecuting these cases. Source: Fox News reporting by Danielle Wallace and Associated Press contributions. Wow, what a year it's been for the Supreme Court, folks. From presidential immunity to social media rights, we've covered some absolutely massive decisions that will shape American law for years to come. These rulings aren't just legal footnotes. They're reshaping how our government works, how our schools operate, and even how we interact online. Looking back, it's pretty clear that 2024 has been one of the most consequential years in recent Supreme Court history. Each of these decisions carries weight that extends far beyond the courtroom, touching everything from executive power to social media freedom, from administrative authority to civil rights. And that's all the time we have for today's special edition of Ranting Politics Headline Updates. If you want to stay on top of these developments and catch more of our daily political coverage, make sure to follow us on X at RantingRP. And for deeper dives into all these stories, head over to rantingpolitics.com. Until next time, keep questioning, keep thinking, and cheers to the coming new year.